Hello, and welcome to Lecture 3 from Topic 4 on the free exercise of religion. This lecture is looking at the free exercise tests that the court has developed to help them rule in free exercise clause cases. The Supreme Court has developed three tests that they have used over the years. The first one you're going to be learning about comes from the case Cantwell v. Connecticut, and it's called the Valid Secular Policy Test. It's a test or a standard that makes it relatively easy for government to infringe upon a person's free exercise of their religion. It's considered a low standard. And it's a relatively easy way for government to justify regulation of religious actions. In the 1960s, the court creates a much more strict test, and it's called the compelling interest least restrictive test, and it comes from the landmark case Herbert v. Werner. This is a much higher or stricter standard that the court uses, and it makes it a lot more difficult for government to justify regulation of religious actions. And then in the case Employment Division of Oregon v. Smith in 1990, the Supreme Court basically returns to a very low standard test, and it's known as the Smith test. And it returns to a much lower standard, making it a lot more easy to government to justify government's regulation of religious actions. It actually goes even back before Cantwell to the United States v. Reynolds case that we learned about in the last lecture. There was a lot of backlash to getting rid of the Herbert test, the compelling interest least restrictive test. And the United States Congress responded. And so the United States Congress passed what's known as the Religious Freedom Restoration Act, RFRA. And this is a federal law that restores the Herbert standard. This is what you're going to be reading about when it comes to the cases in this part of the textbook. And so this just gives you a little guide or outline for what we're going to be talking about in the following slides. So let's get started. The Valid Secular Policy Test is developed, relates to four cases. The test is created in Cantwell versus Connecticut, and that's the case that we're going to talk about. And then the test is applied, or the test is employed in the Minorville School District versus Gabitis test. That is a case about Jehovah's Witnesses students getting expelled from school for not saluting the flag. And Prince versus Massachusetts, which has to do with Jehovah's Witnesses selling magazines and violating child labor law, okay? And you'll be reading, we'll talk about Cantwell in lecture, and you'll be reading about these other cases that employ the Valid Secular Policy Test in your textbook. And then you'll be learning that the Valid Secular Policy Test begins to fray, and that there's a sense in 1961 in the Braunfeld v. Brown case that deals with blue laws, that is, that shops must be closed on Sunday. This is a case about a Jewish man who's, for Jews, their Sabbath is on Saturday, not Sunday. And so he had to close his shop on Saturday due to his religious beliefs, but also on Sunday because of the blue laws. And you see that the court begins to move away from the Valid Secular Policy Test, indicating that they think that there should be a stronger test when it comes to justifying state regulation of religious exercise. So let's take a look at the case that creates this test in Cantwell versus Connecticut. Cantwell versus Connecticut is a really interesting case. This is about the Jehovah's Witnesses. And Jehovah's Witnesses, a part of their religious belief is that they need to proselytize. That means that they need to spread the word, the message of their religious beliefs. You might see Jehovah's Witnesses in your neighborhood because they do a lot of door-to-door solicitation and talking with people. And even though I get kind of irritated today when the Jehovah's Witnesses come to my house, I always talk to them for a little bit, and I actually thank them because it's due to the Jehovah's Witnesses and other minority religions that the court has been given an opportunity to sort of define our free exercise clause jurisprudence. But so anyways, this is about Newton Cantwell, who's a Jehovah's Witness, and his sons. And they, following their religious beliefs, they are going door to door in the Connecticut town of New Haven. They're playing records that the neighborhood that they are soliciting in is a predominantly Catholic neighborhood, and the Jehovah's Witnesses are sort of anti-Catholic. And so the records that they were playing on their phonograph, keep in mind this is 1940, they didn't have a boombox, were announcing an anti-Catholic sentiment. And they were also going door to door soliciting contributions for the Jehovah's Witnesses. And so, like I said, the neighborhood is predominantly Catholic. The message that they were playing on their records was anti-Catholic. And this actually offended some people in the neighborhood, and then they complained about that. The next day, the police come and arrest Newton Cantwell for violating a state law. And the state law says that in order to solicit money, that you need to have a permit. And Newton Cantwell did not have a state permit to go door to door soliciting money. The law states that if you want to solicit, you need to get a permit from the state's Secretary of Public Welfare Council. Basically, the Secretary of the Public Welfare Council is charged with deciding whether the group that is applying for the permit, whether or not they are a truly religious cause, or are they a bona fide charity? Because they don't want sham religions, and they don't want charities that aren't really charities going door to door soliciting money. So in order to prevent that kind of fraud, that you had to go and you had to get a permit in order to solicit money. And if you didn't have a permit, then you were basically in violation of state law. And that's what Newton Cantwell was arrested for. Now, if the secretary found that the group to be neither a religious cause nor a real charity, the group would not get a certificate of approval, and they could not go door to door. Cantwell sues the state. He basically says that the law mandating that he gets a permit violates his right to freely exercise his religion. He thinks that the permit is sort of like a prior restraint. It's sort of like, you can't talk until we give you approval to talk, or you can't exercise your religion until we give you approval to exercise your religion. And so those are the facts of the case. So the question before the court in Cantwell versus Connecticut is, does requiring a permit to solicit money to support religious views violate the free exercise clause? And in an 8-0 decision, a unanimous decision, they find in favor of Cantwell. They say that yes, this Connecticut law requiring a certificate to solicit money is unconstitutional. And let's look at the reasoning of the case to see how they got there. The reasoning that the court offered is as follows. First, the court said that the state can regulate actions that are motivated by religious beliefs. And so, just as we've talked about in the previous lectures, you can believe whatever you want, but that the state can regulate or prohibit actions that are motivated by your religious beliefs. And they said that, making a person who wants to go door to door to solicit about their religion, to proselytize and solicit money for their religion, they said that making that person or group get a permit it has a valid secular purpose, that the state is well within its rights and justified to say that, look, you need to get a permit in order to let people know what the place and the time and the manner in which you can do your proselytizing. In this case, having to get a permit to solicit money prevents fraud. And all of those are valid reasons for demanding a permit. And they have a secular purpose, right? They're not promoting religion. They're not trying to inhibit religion. They're just basically saying that the state has an interest in keeping order and making sure people aren't knocking on doors at 2 a.m. and hassling people for a fraudulent enterprise. But in this case, so you might be saying, well, gosh darn it, why did they find this Connecticut law to be unconstitutional? Well, the reason that they found it to be unconstitutional is because they said that the law was not employed in a non-discriminatory way. So that while it did have a valid secular purpose, it was not neutral in its application. And they said that it wasn't neutral in its application because you had to submit a request for a permit to the Secretary of the Public Affairs Council. And that secretary had the power to determine which religion or which charity, in this case, deserved to get a permit. And so in a way, the Secretary of the Public Affairs Council had this power of censorship. It was up to them to say, oh yeah, if Catholics want to go door to door, that's a legitimate enterprise. It's a legitimate religion. But the Jehovah's Witnesses, no, that's not for real religion, right? Now, it's not saying that the Public Affairs Council would do that, but that giving that permit to an individual and letting them make the decision about who gets the permit, the court said that amounted to censorship, and that applying the law in a non-discriminatory way is unconstitutional. Hello. Looks like we have a new feature on the PowerPoint slide, so we're just going to go with it. All right, so why is Cantwell versus Connecticut an important case? Well, it's important because for several reasons. One reason that it's important is that it incorporates the free exercise clause to the states. Another reason that it's important is because it reinforces the belief-action dichotomy. In other words, belief is absolutely protected, but actions can be regulated. And it's important because it establishes the valid secular policy test, which has 3 prongs. The law must serve a legitimate non-religious goal. The law must be neutral in its application. And the intrusion on the practice of religion cannot be of great magnitude. It needs to be incidental. And so that's why Cantwell versus Connecticut is an important case. The valid secular policy test is applied to 3 cases, and it's in the 3rd case where we see a challenge. The big question coming out of Cantwell versus Connecticut is what constitutes a legitimate state interest? Cantwell gave us some guidance, preserving the peace, safety, comfort, and convenience, because that was the point of why the state wanted people to get a permit. In the case Minersville School District versus Gobitis and Prince versus Massachusetts, we get more of a sense of what constitutes a valid or a legitimate state interest. In the first case, this is about Jehovah's Witnesses and their kids going to school, and that as a requirement for going to school, they had to start each day with saying the Pledge of Allegiance and then raising their arm and saluting the flag. And the Jehovah's Witnesses don't believe that you should not worship a graven idol like a flag. And so they said that it was against their religious beliefs to salute the flag. The kids were expelled from school for failure to live up to that provision of saluting the flag. And Gobitis sued on behalf of his children. In that case, the question is should the children be exempt from the flag salute policy from the school because of their religious beliefs? And the court said no. They basically said that promoting patriotism is a legitimate state interest, and saluting the flag at the beginning of the day is a legitimate state interest, promotes patriotism, and therefore the Gobitis children should be, subject to that valid and neutral law. The same question comes up or a similar question comes up in Prince versus Massachusetts, which is about child labor laws, and whether or not children can be selling magazines on behalf of a religious group. And the child labor laws were seen as a valid, legitimate state interest. Things get a little bit more complicated in Brownfield v. Brown, a 1961 case. And this is a case having to do with blue laws. In this case, the gentleman was an observant Jew, and his Sabbath was on the Saturday. So he had a shop, and he didn't want to open his shop, his business on Saturdays, because that was his day of worship. But there was a law in the book saying that all shops must be closed on Sunday because it was seen as a day of rest. And Braunfeld said that he should be able to open his shop on Sunday because having to close on Saturday and Sunday really was a big economic burden to him. And that in order to make economic ends meet, he'd have to choose between his worshiping on Saturday or opening his business. And he didn't think that he should be subject to that sort of a choice. It's not a real choice to choose between your religion or economic viability. And in Brownfield, they found for the state, they said that the blue laws were constitutional, although they begin, in the dissents suggesting that, look, having a day set aside for rest, Sunday, it is not really justify trampling upon somebody's religious beliefs. And so in Brownfield, we get a sense that maybe a new test is needed, and we got that in the next case. This brings us to the case Herbert v. Werner. And this is a picture of Adele Herbert. And as you'll read in the textbook, this is a really interesting case. Adele Herbert, she lived in South Carolina, and she worked in a textile mill. She was a spool tender. And she worked in this textile mill for 35 years, for a long period of time. And she worked every Monday through Friday from 7 in the morning until 3 p.m. in the afternoon. In her 36th year of work, she was told that she now needed to work on Saturdays, that they had mandatory, non-optional Saturday overtime, and that she needed to work on Saturday or she would lose her job. She's a Seventh-day Adventist, and much like Jewish folks, Seventh-day Adventists, they see their Sabbath day not as Sunday, but they see it as Saturday. And so she, said she cannot come to work on Saturday for the mandatory overtime because that is her day of worship. She stopped coming to work on Saturday, and she was fired about 2 months after the new policy went into effect. She tried to look for another job, but all the other jobs that were all the other mills around where she lived, they also had mandatory overtime. And so there was no place that she could find a work that didn't demand that she work on her day of Sabbath. So she filed for unemployment benefits. This is an unemployment benefits case, but she was denied. And the reason that she denied was that they said she wasn't eligible. She was offered suitable jobs at other mills, and she didn't take them. And the reason she didn't take them is because they had mandatory overtime on Saturdays. And since she was offered suitable work but refused without good cause, that made her ineligible for unemployment benefits. She sued, but the lower courts ruled in the favor of the unemployment office. And so the question before the court in this case is, may a state deny unemployment benefits to persons whose religious beliefs preclude them from working on Saturday? And the court decision was no, they cannot deny unemployment benefits in a 7-2 vote. So let's take a look at the reasoning and the development of the new compelling interest, least restrictive test that the court creates coming out of Herbert v. Werner. In Herbert v. Werner, the court offers this reasoning for why the law is unconstitutional. First, they say that denying Sherbert unemployment benefits does infringe on her religious practice. The question is the state justified in doing this? And that's the question that's the case that the court has wrangled with in the other cases. Is the court justified in demanding that somebody get a permit if they want to go proselytizing door to door? Are they justified in making a Jehovah's Witness salute the flag? Are they justified in not allowing children to sell pamphlets to promote their religion? So it's always a question, is the state justified in doing this? And what the court says is that to justify this infringement on religious practice, the law must do these things. The law must be based on a compelling state interest, okay? Not a legitimate state interest, but a compelling interest. And that it has to be achieved in the least restrictive way possible. And that's why the test is called compelling interest, least restrictive way. This is what's known as the Herbert test. So, is the infringement justified? The court says no. That for it to be justified, the state must demonstrate that it's opening itself up to the gravest level of abuse, and that that allowing somebody to get unemployment benefits is a danger that would threaten a paramount interest of the state, like national security or some other paramount interest. And they said that in this case, it just doesn't rise to that level. The state has no evidence that granting this exemption to Herbert would open itself up to grave dangers or abuses. And they also said that even if there was evidence of fraud, that because Herbert got the unemployment benefits, that other people would come in and say, oh, I can't work on Saturday, not because of religious beliefs, just because they don't want to work, and that they would be able to fraudulently get the unemployment benefits. They said that the state needs to demonstrate that denying benefits is to everybody is the only way to prevent fraud. And they said that the state did not demonstrate that. And so that's why they found the law to be unconstitutional. Herbert v. Werner is an important case because it establishes the compelling interest test. It also introduces the idea of balancing of interests. And what balancing of interest is, and you're going to see this referenced when we read the Smith case, the balancing of interest is that that it's sort of like you look at the interests of the state, and then you look at the burden placed on the individual, okay? And that if the interests of the state are of a greater magnitude than the magnitude that's placed on the burdening the rights of the individual, well, then if the interests of the states are greater than the burden that the individual is experiencing, then the court will rule in favor of the state. On the flip side of that, if the magnitude of the burden placed on an individual's infringement of their rights is greater than the magnitudes of the interests of the state, the court will find for the individual. And so it's sort of this case-by-case sort of balancing of interests approach that the court is taking when it comes to free exercise cases. They're saying, what's the magnitude of the burden placed on a person's religious free exercise? What's the magnitude of what the state's concerned about achieving in terms of their goal? And then they'll do a balancing and they'll go with whichever has more weight. This is created by the Warren Court, the Earl Warren Court, but it's soon after this, Warren Burger takes over as Chief Justice. And so there's, as you'll read in your textbook, that the test is applied by the Burger Court. And there's some wondering about how this test is going to be applied. And so it's applied in Yoder v. Wisconsin, the Thompson versus the Review Board of Indiana Employment Division, and then the Bob Jones University case. Versus the United States. I'll let you read about these in the textbook. And I encourage you to come to office hours to talk about these cases because they're very, very interesting. This slide is just a little tantalizing to encourage you to read the case. Obviously, you're going to read the case, but also to encourage you to maybe come and discuss it during office hours. This is a picture from 1965 of Amish children fleeing police and truancy officers, not in Wisconsin, but in Hazleton, Iowa. And so, that's what Yoder versus Wisconsin is about. Yoder versus Wisconsin is about that states have on their in their state laws compulsory education, and they're telling people that they have to send their kids to school until they're 16 years old. And the Amish did not want to send their kids to school after the age of 12. They didn't want their kids to be educated after 8th grade, so 12 or 13, however old you are. And so these kids, they were not going to school, and the truancy officers were chasing after them. And so that's the question that comes to the court in this case, and I'll let you read it, and hopefully we'll come and discuss it, about whether or not a family can be exempted from their compulsory education laws. Is it okay because of the Amish's religious belief to deny their students a high school education? And so read it. You can think about doing your case brief on it. It's a very interesting case. Just as we see with the valid secular policy test and how it begins to, you can see that the court is kind of changing their thinking about whether or not it's a good test to employ in free exercise clause cases. We see that same thing happening in the in the 1980s when it comes to the Herbert test. So starting in the 1980s, it seems as if the court is starting to move away from the Herbert test, that maybe they are thinking that it's giving too much protections to people to exercise their religious beliefs, and that it's not giving the state enough power to regulate the behavior. And so there are two cases that you'll read about in your textbook that lead to the fraying of the Herbert test, and then it's an employment division of Oregon versus Smith, where the Herbert test actually meets its demise. United States v. Lee is a case about an Amish gentleman who runs a business and he doesn't want to pay Social Security taxes for his employees because it says it goes against his religious beliefs. And the court says, nope, you need to pay those taxes. So again, it's not, there's this suggestion of, is the Berger court kind of moving in the direction of providing less protections for the individual? And in Goldman v. Weinberger, that's also an interesting case you'll read about. That's a case about an officer within the armed services who serves as a psychologist. So he's not like on the front lines, but he's an observant Jew, and he wears a yarmulke, which is a hat that you wear to signify your religious belief. And he goes and he testifies in court because he's a psychologist in a military court, and people see his yarmulke and they say that violates the uniform code for the armed services. So you need to, when you're in uniform, you need to take your yarmulke off. And in that case, they found for the United States government, for Weinberger was the Secretary of Defense at that time. And they said that the uniform code of the U.S. military is very important, and that it justifies the infringement on Goldberg's desire to exercise his religious beliefs through wearing a yarmulke. Let's now talk about the landmark case, Smith. This case, the Employment Division of Oregon v. Smith, is very similar in some ways to the Herbert case because it deals with somebody who gets fired for their job for engaging in, for exercising their religious beliefs, and then they are apply for unemployment and benefits, and then they are denied them. This is also a case that centers around the use of peyote for religious practices. Peyote is used as a part of a religious ceremony by the Native American Church. At this time, 23 states, as well as the federal government, had an exemption for the use of peyote for religious purposes, but that was not the case in Oregon. In Oregon, possession and selling of peyote was a criminal offense. The drug was illegal to possess in Oregon without a prescription. So the dispute in this case is over two gentlemen, Alfred Smith, who is in the photograph there, and his coworker Galen Black. They're both Native Americans, and they were fired from their jobs at as drug counselors for ingesting peyote during a religious ceremony. They lost their jobs because of that. And then they sought unemployment benefits, much like Adele Sherbert did, but they were denied these benefits. They were denied because they were fired for misconduct, consuming an illegal substance. And Smith said, look, just like in Sherbert, you can't deny me the benefits because, for one, I wasn't charged with the criminal conduct. I was just fired, said Smith and Black. But also they argued that the state couldn't deny them the benefits because that they were practicing their religious beliefs. So in many ways, this case is very similar to the Sherbert case, but the outcome is very different. So the question before the court is, may a state deny unemployment benefits to those who lost their job because they violated general law, a general criminal law, even when the action taken was based on religious convictions? And the decision of the court in a 6-3 decision said that yes, Oregon may deny these two gentlemen unemployment benefits. It was a 6-3 vote, and the opinion is written by Associate Justice Antonin Scalia, and which you're going to be reading about in your book, not about this opinion, but you'll be reading about Justice Scalia, and he's got a very large personality that you'll be reading about. So let's look at the reason that Scalia and the court offers in this case. So let's look at the reasoning that the court offers in Smith. Sorry, the print is so small. But what they basically said is that the court has never held that an individual's religious belief excuses him from compliance with an otherwise valid law prohibiting conduct that the state is free to regulate. And so Scalia references Reynolds, which is that early case that we learned about the Mormons, Prince, which is the child labor laws, Braunfeld, which is the blue laws, and Lee, which is the case having to do with paying Social Security taxes. So he's basically saying the court has been pretty consistent when it comes to not excusing people from compliance with laws. And what he does, which is kind of a little bit of a tricky move that Scalia makes, is he says the only time the court found that the laws didn't apply was in hybrid cases. And that's where speech and religion were combined and where parental rights and religion were combined. Okay. And so Cantwell was about proselytizing speech and religion, and that Yoder is about parents being able to make decisions about their kids and religions. And so he's basically saying that, if you're looking and saying, wait, you're being inconsistent here, he's saying like, oh no, that when we did exempt people from law, it was because there were two liberties that were going on at the same time. He says that it's the standard that was used in Reynolds is what applies here. So this Smith brings us all the way back to, a decision in the 1890s that basically people are not exempt from valid and neutral laws because of their religious beliefs. And he says that we don't consider balancing government interest with an individual's spiritual development as a sound approach, especially as it relates to criminal law. And so that's where he sort of sees this case as different than Sherbert, because in Sherbert, it was really about unemployment benefits only. And it's very likely that had Scalia been on the court at that time, he wouldn't have ruled in favor of Sherbert. But in this case, this is about somebody who gets fired because of criminal conduct, taking peyote. And he says that basically it allows a person to pick and choose the laws they want to follow, permitting the individual by virtue of his beliefs to become a law unto himself, which results in anarchy, right? And so, that is Smith kind of in a nutshell. It basically is saying we're throwing out the compelling interest standard, and that we're really going back in time and replacing it with sort of the valid secular policy test, but really just that general laws that have general applicability apply to everybody, regardless of what their religious, regardless of whether it has an impact on their religious practice. In response to Smith, Congress passes the Religious Freedom Restoration Act in 1993. When the court makes its decision in Smith getting rid of the compelling interest test, there's a huge backlash. Both liberals and conservatives are angry that the court is now going to use this lower standard because they feel that people's religious practice will not get as much protection. And so the RFRA codifies the compelling interest standard into federal law. Basically, it says that federal law says that if a federal, state, or local government wants to have a law on the books that infringes upon somebody's free exercise of religion, they can only do that if they can demonstrate that there is a compelling interest and that they're doing that in the least restrictive way. That law is challenged in the case Borney, which you're going to read about, and basically saying that that law is unconstitutional. And what the court says is that they don't find all of the Religious Freedom Restoration Act as unconstitutional. They only find that the provision of that act that applies to state and local governments is unconstitutional, because they said that Congress, at least in this law, did not have the power to make state and local governments employ that compelling interest standard. That was beyond that they could only make the federal government do that. They couldn't apply it to the states and local government. And so that the national feature of the Religious Freedom Restoration Act applies still today. And it's tested in Burwell versus the Hobby Lobby stores. In that case, that there's a national law of the Affordable Care Act that says that companies with more than 20 employees have to provide health insurance for their employees that include access to birth control. And the people that own Hobby Lobby are really religious, and they said they shouldn't be able to be forced to pay for contraceptives for their employees because it went against their religious beliefs. And using the RFRA, they said yes, that Hobby Lobby should be exempted from that. Woo! That's a lot of free exercise clause jurisprudence. So, and there's more in the textbook, right? So, sorry the presentation is so long, but there's just a lot to cover. We'll be setting up additional office hours, as I've said, to discuss cases, because cases rock. And also you have a really cool discussion this week that allows you to put what you're learning, particularly the clash between civil liberties and civil rights, religious practice and anti-discrimination laws, when they come clashing together. So you're going to be able to apply this and take it to the next level in your discussion, which I'm looking forward to. Thanks for paying attention, and I'll talk to you again soon.